Now we will discuss the remedies which are available to the shareholders in case of this operation and mismanagement. Section 241 of the Companies Act 2013 provides that any member of a company who complains regarding any operation or mismanagement being occurred in a company may apply to the tribunal. Moreover, even the central government, if of the opinion that the affairs of the company are being conducted in a manner prejudicial to the public interest, then it may itself apply to the tribunal for an order. In this module, we will discuss 3 different actions which the shareholders can take, that is personal action, derivative actions and class action. Personal action. In this, the shareholder claims their personal right which arise from the constitution of the company. This constitution of the company is memorandum of association and articles of association. So, the rights which each and every shareholders have, which right they get from the memorandum of association or the articles of association, these are the personal rights of the shareholders, and the shareholders can claim those rights without any help from the any other shareholders. So, these are the personal rights, and for these personal actions can be taken by the shareholders. But however, in Indian companies law, personal actions of the shareholders aggrieved from the acts of operation or mismanagement do not possess any statutory provision. Now we come to another action, that is derivative action. It is a very important. An interesting area of law is the law governing derivative action, which enables the shareholders of a company, that is mean group of shareholders, to bring an action on behalf of the company against a third party before a regular civil court. Again, there is no specific statutory provision for the derivative action claim in the Indian companies law. However, the doctrine of derivative action is recognized by the Indian courts. If a shareholder alleges that a wrong has been done to the company by persons in control thereof, he may bring a derivative action where he derives the authority from his corporate right to sue on behalf of the company. The premise on which the court entertains this extraordinary form of action is upon the complaining shareholder assertion that the company cannot sue as the persons in control would not bring an action on its behalf for its benefit. Now, derivative action is basically defined as an action by one or more shareholders of a company where the cause of action is vested in the company and relief is accordingly sought on its behalf. Since the company has a distinct legal personality with its own rights and liabilities which are different from those personal rights of individual shareholders, this action is brought by a shareholder not to enforce his or her own personal right. I will repeat that since the company has a distinct legal personality with its own rights and liabilities which are different from those personal rights of individual shareholders, this action is brought by a shareholder not to enforce his or her own personal rights, but the right and liabilities of the company on its behalf and for the benefit of the company, which the company cannot itself do as it is controlled by wrongdoers. Now, in order to be classified as a derivative action, the following aspects must be satisfied. Firstly, it must be brought in a representative form, that is, though it is a company rather than the other shareholders whom the person initiating the legal action or proceeding seeks to represent. By implication of all other shareholders are bound by the result of the action. That is, a group of shareholders came together and they file a suit in a representative form. Here, whatever be the result of that action, all the shareholders will get affected by that. Now, although the action is brought on behalf of the company appears as a defendant, so that the action takes the form of a representative action by the initiating shareholders on behalf of himself and all other shareholders other than the alleged wrongdoers. I mean, though shareholders doesn't include the wrongdoers also, and this action is against the alleged wrongdoers and the company. So, shareholders are taking action in a representative form against the company as well as against the wrongdoers, and these wrongdoers are the part of the company itself. They are also the shareholders of the company. The derivative action may be brought by a shareholder or shareholders in the following instances. First is ultra vires. A shareholder may bring an action against the company and its directors in respect of matters which are ultra vires the memorandum of association or the articles of association of the company, and which no majority shareholders can sanction. For example, directors of the company sanctioning an action that is contrary to the objects of the company. So, objects, as I must told you that the objects of the company are the basic things on the basis of which the company is tending its building or its business. If the company fails to satisfy those objects, then the main purpose of the establishment of that company get failed, and then the existence of the company is not at all allowed, not even by the court or by the other person associated with the company, like its creditors. So, if the directors of the company sanction an action which is contrary to the objects of the company, that is an ultra vires act, and in that case the derivative action can be taken by the minority shareholders or any shareholders which get affected by that action. Next is the fraud on minority. Directors and the company would also be liable if the conduct of the majority of the shareholders constitutes a fraud or minority, that is a discriminatory action. For example, where the shareholders have passed a special resolution with an effect of discriminating between the majority shareholders and minority shareholders, so as to give the former an advantage of which the latter were deprived. I repeat the example again, where the shareholders have passed, these shareholders are majority shareholders, that is shareholders who are in control of the business. So, where the shareholders have passed a special resolution with an effect of discriminating between the majority shareholders and minority shareholders, so as to give the former an advantage of which the latter were deprived. Former is the majority shareholder and the latter is the minority shareholder. So, in such cases, it is a fraud on the part of the majority shareholders on the minority shareholders, and in such case also the group of minority shareholders in a representative form can take a derivative action in the court. Another is required resolution, that is certain actions of the company can be approved only by passing a special resolution at a general meeting of shareholders. So, if the majority seek to circumvent this legal requirement and pass only an ordinary resolution or do not pass such a special resolution in the manner required by law, then any member or members can bring an action to restrain the majority. The majority shareholders and minority shareholders, they both are the part of the company. The interest of both the majority as well as the minority shareholder need to be protected. So, there is no need for the majority shareholder to take action by themselves and do not involve the minority shareholders with them. It is a duty that whenever they take any crucial actions which need any special resolution and will need the assent of the minority shareholder, they have to get that assent. They cannot exclude the minority shareholder, they cannot neglect the interest of the minority shareholders. Another one is to safeguard interest of the company. For example, an obvious wrong may have been done to the company by the directors, but because of the control of such directors on the majority shareholders, such shareholders may not permit an action to be brought against the wrongdoer, directors. Therefore, to safeguard the interest of the company, any member or members may bring a derivative action. So, as both the majority shareholders and minority shareholders are liable or as well as responsible for the company, they are responsible on behalf of the company. They have to maintain the goodwill of the company. So, if the minority shareholders came to the opinion that the acts of the majority shareholders are not in favor of the company, or that they are doing any act which is frivolous to the interest of the company, then in such case minority shareholders can take an action against those majority shareholders for the interest of the company. Next is the individual membership rights. As a general rule, personal rights per se are not to be enforced through derivative actions. However, some exceptions have been recognized. These exceptions often arise in case of rights that have been conferred upon the shareholders by the Companies Act itself or the respective articles, which is known as individual membership rights. For example, the right to vote, the right to have one's vote recorded, or the right to be nominated as a candidate for the post of a director during the election of directors at a general meeting of the shareholders. Prevention of oppression and mismanagement. A representative action may be brought for prevention of oppression and mismanagement, which are cases where the majority acts in a manner that oppresses the minority, where the majority acts in a manner which oppresses the minority, or where the affairs of the company are being conducted in a manner prejudicial to the public interest or oppressive to any member or members, or in a manner prejudicial to the interest of the company, including an adverse material change in the management or control of the company. Since these proceedings are initiated for the benefit of the company, it can be considered a form of derivative action and find specific place in the scheme of the Indian company law under the Companies Act. In order to obtain relief, the Company Law Board can be approached by not less than 100 shareholders or not less than 1/10 of the total number of members, or members holding not less than 1/10 of the issued share capital of the company, provided all the dues of the shareholders have been paid by the applicants.